I welcome you all to the third phase of the International PhD in Progress Weekly Seminar Series organized by the Global South Network, GSN. The first phase and the second phase of the series took place between May and December. Students and staff from 8 disciplines, 22 universities, and 8 countries participated in the series. The second phase started today and will end in December 2024. Thanks to the organizer of this weekly seminar series, Dr. Noman Rayat, lecturer in law at Leicester Law School. He is the founder and convener of the Global South Network. Unfortunately, so allow me to introduce today's panel as well as myself. My name is Dr. Sabine Franklin. I am a Mellon Postdoctoral Fellow in Africana Studies at Wellesley College in the United States. I will be chairing the session today. I am joined by Dr. Asmahan Musa, a lecturer in law in the School of Criminology at the University of Leicester, who will be the discussant for today's session, as well as Somabha Bandopadhay, PhD at the National University of Juridical Sciences in West Bengal, India. He is the peer commentator for today's session. Somabha is a teaching assistant at the West Bengal National University of Judicial Sciences, which is in Kolkata. She is a visiting research fellow at the School of Criminology, at the University of Montreal. And further, she is also a recipient of the Indo-Canadian Shastri Mithaks Research Scholarship. Somabha recently passed her PhD Viva in December of 2023, so congratulations. And her PhD research focused on violence, victimization, and human rights of the transgender community. Then we have Erini Yementizis, who is currently a PhD student at the University of Strathclyde in the UK. She is pursuing her doctorate in the field of law. Her areas of interest span the legal field, ranging from competition law to data protection and technology. Her research currently delves into the intricate world of digital platforms within the digital economy. Her primary focus is on the market power held by these digital giants and the regulatory landscapes that govern them across various countries. Today, Erini will present her project titled Mirroring the EU Digital Market Act to Tackle Technology Giants' Anti-Competitive Conducts in South Africa. Erini, you have 25 minutes for the presentation, which will be followed by 5 minutes for comments and questions of the discussant and the peer commentator, and 15 minutes of questions and answer sessions by the attendees. The floor is now yours.
Thank you. Good afternoon, everyone, and thank you all for being here and for allowing me to share my research with you. Yes, my name is Erini Yementizis, and I'm from the University of Strathclyde, and I'm here to present a paper that myself and Dr. Jing Wang from the University of Leicester have been working on. It discusses the question on mirroring the Digital Market Act and to tackle the technology giants' anti-competitive conduct in South Africa. In terms of the contents of the presentation, I will begin with a summary of my PhD research, just generally summarizing what my research focuses on, and I will also link this to the paper that I'll be presenting today. I'll move on to some background information on digital markets, and then discuss the approach adopted both in the EU and in South Africa, with closing off with some final remarks and my conclusions. And so moving on to the summary of my PhD research. Generally, my research aims to provide an analysis of the existing legal frameworks and their inadequacy in capturing the realities and actualities of how powerful digital platforms acquire and exercise their influence within the digital economy. My research generally seeks to understand the intricacies and the nuances of this phenomenon and shed light on the gap in the current regulatory landscape. My research aims to illustrate that the standards used are too narrow and do not sufficiently address the harms caused by digital platforms within the digital economy, and it therefore seeks to assess whether it is necessary to construct new standards or benchmarks within these existing frameworks in order to ensure better protection for consumers against dominant firms within the digital economy. Today's discussion will specifically focus on whether the EU's Digital Market Act should be mirrored in South Africa to tackle these conducts. The reasoning from my research has to do with when I was conducting my literature review and doing wider reading on the approaches adopted by other countries and jurisdictions. I took a particular interest into South Africa. Main reason was because they've been pretty active within the digital markets and have recently released their market inquiries into this. The methodology I've adopted is a mixed methods approach, and it combines black letter law with comparative study between the EU and South Africa. So moving on to the background in digital markets. In recent years, there has been an apparent transformation in the traditional economy. One of the impacts of this has been the wider digitalization of every aspect of society, from the way individuals work to the way they socialize. And the speed and the measure of these technologies that have been introduced have generally been overlooked for quite a while. It's more in recent years that competition agencies have been trying to tackle the issues that they have created. And at the center of this shift has been essentially technology firms or digital platforms. Maybe 10 years ago, Microsoft was one of the biggest technology firms. Now in 2023, you can see in the table that a majority of the companies listed on the top 10 companies globally are considered digital platforms, and they tend to operate in various markets. When discussing the main players and key digital platforms, it usually revolves around 5 companies, and that includes Google, Apple, Facebook, Amazon, and Microsoft, or they're widely known as GAFAM. While there is no universal definition for digital platforms, a common theme is that these companies are more often than not able to shape the interactions that not only individuals have, but also the interactions that companies have with consumers. The concerns relating to these firms will vary, but generally digital platforms and their anti-competitive practices have been recognized by various organizations. The United Nations, for instance, has said that they think the digital platforms are a growing threat to business users and to consumers across the world. As such, this presentation will kind of look at the approaches adopted within the EU and South Africa and to evaluate their effectiveness and their ineffectiveness in promoting competition by specifically focusing on Apple and Google's behavior and within their respective markets. So if we move on to the EU approach, there have been various investigations and cases carried out by the EU Commission. And although for many the DMA signified a major change, it also signifies an accumulation of what has been learned from these cases. In fact, the DMA and the approach adopted by the DMA largely aligns with the EU's previous investigations into Google and Apple and their anti-competitive practices in the 2010s and 20s. Take Google, for example. In the last maybe 3 years, they've been fined over 8 billion euros by the EU Commission for abusing their position and adversely affecting both competition within the market and consumers. Several cases within the EU, they cover a wide range of areas. This could include things such as unfair agreements to anti-competitive practices. But due to the time constraints today, I'll be focusing on two points in particular. The first being the Google Fitbit case. It should be noted that this case was scrutinized both in the EU and in South Africa, and the case concerned Google acquiring Fitbit, which was a US-based company that makes and sells wearable devices, such as smartwatches. The concerns largely related to the aggregation of user health data held by Fitbit and the already extensive amount of data held by Google. The merger was allowed to continue, but it was based on several conditions put forward by the EU and South African Commission. One of the conditions being the assurance that the data sets from Google and the data sets from Fitbit would be kept separate and they would not be combined. The second area I want to raise is the investigations into Apple. These investigations have been launched since 2020. They're still ongoing, and the investigations concern two issues. One being the charging of app developers a commission fee. These commission fees range from 50% to 30%. And the second being the prevention of consumers from using alternative means of payment methods. The investigations, as I said, have been launched, but no decision has been made. But it is important to note that the DMA has tackled one of them. That is the issue on preventing consumers from using alternative payment methods. I'll discuss this further later on in the presentation. But on the second issue, it has failed to challenge the issue of high commission fees, and that is still something that has not been dealt with effectively. So if we look at the DMA in more detail, the DMA was enacted in 2022, and it essentially establishes a set of narrowly defined objectives for online platform gatekeepers. The main purpose is to ensure that gatekeepers do not abuse their dominant position by abusing either competitors' interests or the interests of consumers. So the overall aim is to ensure a fair and competitive digital environment and ultimately create a digital level playing field. The DMA therefore aims to identify certain gatekeepers, which it considers to have a dominant position within their respective market. And to do this, the DMA defines what a gatekeeper is in Article 3. It looks at if the platform has a significant impact on the internal market. It looks at providing if the platform provides a core service, which may be an important gateway for business users to use to reach end users. And it finally looks to see if the platform enjoys an entrenched and durable position in its operations or foreseeable. And under the DMA, the EU Commission will look at a range of factors that they consider to decide if the company is a gatekeeper or not. For instance, they may look at the company's turnover, the size of the company, the number of users that the company has, and this is just a small list of the many factors that they may take into consideration. I also want to highlight that in September 2023, the EU Commission designated for the first time 6 gatekeepers, and they include Alphabet, or better known as Google, Amazon, Apple, ByteDance, Meta, and Microsoft. These companies need to ensure that they comply with the DMA, and this is from within the 6 months. Several of these companies have challenged their designation, but the focus now is on complying with the DMA. The DMA can largely be viewed as an accumulation of the lessons learned in the investigations that I discussed in a previous slide. And in particular, Article 5 prohibits, to list a few, the platform from prohibiting gatekeepers platforms from requiring business users and consumers using their platform to exclusively use the platform's own payment app, which when they're making or receiving payments, this could be with the use of Apple Pay or Google Pay. In addition, Article 5 states that the platform must not use the personal data of the platform and end users for the purpose of online advertising. If we look at examples of platforms, this may be through Amazon or through Google. Another prohibition in Article 5 is that platforms must not combine users' personal data unless the consumers or end users have given consent to this. And then again, these parallels can be seen with the case in Google Fitbit. In addition, Article 6, amongst other things, states that the gatekeeper shall apply transparent, fair, and non-discriminatory conditions to such ranking without applying favorable treatments to certain sellers or to the gatekeeper itself. If we take an example, Google search, for example, cannot prioritize companies who've paid them to advertise on their Google search and cannot act favorably to their own products or services. And it's through these investigations, the EU Commission has identified certain behaviors that they have now established and deemed as firm objectives of the DMA in order to prevent similar conducts from occurring in the future. And Articles 5 and 6 essentially form the do's and do nots of the companies, and these will be the factors that the companies need to comply with in the future. So this brings us to the question on, is the DMA leading the change? And to a certain extent, it is true that the DMA has brought positive changes to the EU digital market by incorporating the lessons and the factors that they've considered within their investigations. However, it also represents a lost opportunity to a certain extent, and we have identified certain ones so far. Firstly, the DMA fails to provide a basis to challenge the high commission fees established by platforms. In addition, the DMA fails to provide compensation to consumers who have been adversely affected. Thirdly, the DMA has failed to create a provision for increasing fines beyond the usual level of antitrust fines. And I mean, it could be contended that the financial penalties that are used are rendered ineffective considering the amount of profits that these companies or entities generate. It raises the question of whether there is any efficiency or productivity in using such fines in deterring non-compliance behavior and promoting the ethical business practices that the DMA wants to achieve. Finally, the DMA has also failed to improve its merger provisions to prevent killer acquisitions. To just briefly define killer acquisition, this is generally where a company will acquire a company that may be innovating or it may look promising with the purpose of eliminating it as a future competitor. This is a common concern within the digital economy, given the size and the financial capabilities of certain digital platforms, such as GAFAM. And this was a concern that was also raised in the Google Fitbit case once it was decided. Moving on to the current state of competition law in South Africa. In comparison to the EU, the South African Competition Commission has generally attempted to take a broader socio-economic and public interest when taking into these considerations. This is indicated in the preamble of the 1998 Competition Act, where it states that efficient, competitive economic environment, balancing the interests of workers, owners, and consumers, and the focus on development will benefit all South Africans. This, in comparison to EU competition law, where the focus is on leveling the playing field, guaranteeing choice, focusing on fair pricing and efficiencies. It can be argued that in recent years, competition agencies around the world have become increasingly proactive in identifying and developing a new approach to regulating digital markets. The SACC report, for instance, indicates this South Africa's willingness to try and interact and have more regulatory oversight of both technological advancements that are taking place within the digital market. Furthermore, on South Africa's approach, digital platforms have generally, in the last few years, faced increased scrutiny within South Africa. For instance, the small merger guidelines have aimed to correct under-enforcement of mergers, and this was introduced in 2022. It can be seen as a direct response to the decision in the Google Fitbit case, where although the merger didn't meet the necessary thresholds, it can still come under scrutiny. And this deals with the issues of larger firms acquiring smaller firms and trying to get rid of competitors in the future. In addition, the more recent online intermediation platform market inquiry report was published by the Commission in July 2023, and it was initiated due to the South African Commission having concerns relating to certain features of online intermediation platforms. In particular, the inquiry aimed to assess if the features of certain platforms impede, distort, or restrict competition. This was to see if there was having any impact on small or medium enterprises and historically disadvantaged persons in the market. The inquiry looked at a range of markets, but our paper specifically discusses its assessment on Google and Apple. The inquiry found that Google search holds 90% market share in search activity across devices. And when it comes to ranking on pages, paid results and Google's own goods and services were given more prominence. This significantly impacts the companies with a smaller marketing budget, but also fails to allow domestic businesses to gain visibility amongst these results. In order to remedy this, the inquiry suggested providing greater visibility and funding for training of domestic and small companies. And it also stated that Google must stop favoring its own products and must comply with the DMA when it comes to issues such as self-preferencing. When considering the inquiry's outcomes of the application stores, it found that Google and Apple app stores impose unrestricted commission fees on developers, and that the anti-steering rules limit app developers guiding users to alternative options. It also found that there was a lack of South African app curation, which thereby obstructed domestic app developers from competing effectively within the market. And in order to remedy this, the inquiry suggested to list a few that the app stores must allow app developers to use alternative payment mechanisms, and they must also allow for South African curation. They also suggested that the South African flag be used in order to credit local app developers. Finally, the inquiry suggested that the companies must implement the measures mentioned within the EU's DMA. To conclude, as we have seen, there have been several investigations conducted within the EU on Google and Apple, and all of these investigations have established a base for change that has been brought about by the EU DMA. Although the DMA is a positive advancement in better regulation, it is also suggested that there has been some limitations in the DMA. We can also see that South Africa's Commission has always also been interested in interacting more with the DMA, and this was largely found in the market inquiry. However, due to the gaps that exist within the current DMA, we argue that at this stage, the South African Commission should not mirror the DMA. Although the recent developments within South Africa, within the South African competition regime illustrate that it has been proactive in adapting its approach to digital platforms. Both the small merger guidelines and the market inquiries and reports indicate this. There are also some limitations in the Commission's approach in South Africa. For instance, the Google Fitbit merger is one of the limited mergers in GAFAM that has come under scrutiny in South Africa. In addition, it may be argued that both the EU Commission and the South African Commission were not skeptical enough of this merger. The 2023 report indicates that the South African Commission is attempting to interact with the digital market more. So it's important to see what the impacts and outcomes of these inquiries will be. It could be argued that if the South African Commission were to establish a regulation similar to the DMA in the future, then it would have to take into account certain considerations like the legal, economic, and social realities of South Africa, and not merely mirror it. But for now, I believe the focus should be on assessing how these platforms impact the markets within South Africa. And given the goals that the Commission want to achieve, they should maybe try pursuing more enforcement through cases and investigations. This may be a more beneficial approach to take by the Commission rather than formulating a regulation at this stage. In the future, the South African Commission may want to learn from the DMA and its limitations, and at that point it may be beneficial to introduce a regulatory framework similar to the DMA, but even in that case, I don't believe that it will ever mirror it, since the realities in South Africa are very different, and the goals that the Commission want to pursue will vary to the EU's goals. Just got some references there, and thank you all for listening.
Thank you, Erini, for your presentation. So now I'd like to pass it on to the discussant, Dr. Nsuya.
Right, yeah, thank you very much for your, can you hear me, all of you, yeah?
Yes.
Great, yeah, thank you very much for that kind of very insightful presentation. It was interesting to listen to it and to learn a lot of it, because I don't have any background in business or technology, so I was learning as you go along. So I find it very, very interesting. But what is really, really interesting as well is to take that comparison of the global north and global south, because the economic strength as well make a huge difference. During those days before the 21st century, a global south, we could say, okay, we can compete probably more equally to the global north, because we were looking on material goods as something as resources, but now focus has moved to technology. Now those who have technology, they have more power compared to those who have any other sort of resources. So I find this very interesting, and I was trying to compare to my area of expertise, which is within law and sociology and all that kind of things. But it is a very, very interesting. Very interesting with the approach. I think the methodology is excellent as well, as you are taking a very comparative methodology. But I have one question in relation to that. I don't know if you can able to explain a little bit about the black letter approach. How does it work, and how did you implement it? Because it looks like a very kind of a unique approach, and I would like to hear a little bit more on that area and learn more from that. And also, I'm not sure, you explained something to do with DMA leading. Were you kind of comparing and suggesting maybe later on in your studies, are you going to suggest that South Africa need to learn more from EU approach? And if that is the case, then probably you need to be a little bit cautious, because these are two different societies with a very different social layout, socio-economic strength, and so on. So probably while we're doing a comparison analysis, probably there's a lot of other factors that you need to bear in mind where you compare the two countries, which have a very different position in terms of the socioeconomic strength, but you also need to consider the political situation, especially historically for South Africa issues. And actually the use of technology itself. I know South Africa is one of the sub-Sahara societies that they utilize technology more compared to the rest of the sub-Sahara Africa states. However, there's a large percent of population that they don't even have electricity. So you can't really make a very competitive or very clear difference in terms of comparison of these two different societies. Yeah, so that is my view, and there's some few questions in there. Otherwise, this is excellent presentation, and thank you very much for sharing. Yeah.
Thank you. Sabine, I think your mic is off.
Yeah.
Yeah. Thank you, Dr. Masaya, and thank you, Erini, for pointing that out. Erini, would you mind unsharing your screen, because we can see, we can all see ourselves while we're seeing ourselves. It's a little weird. Okay, thank you.
Sorry.
Great now.
I guess before we move on to the peer commentator, I don't know, Erini, did you want to have a chance to respond to Dr. Masuya's questions?
Definitely. In terms of the first question on the black letter approach, generally this consists of just taking a look at what the statute says, what the cases are saying, the kind of reasonings within the cases that have been used, but also looking at the wider literature, what is being said within the EU, what is being said within South Africa. I found that when I was doing the research, there was a lot less research coming out of South Africa. Again, this was one of the incentives for me to conduct this research. I thought it'd be a good comparison and a good addition to the academic environment. And in terms of the question or your concerns about the research on the socioeconomic needs and what's happening in South Africa compared to what's happening in the EU, I think that's definitely a consideration that we will consider when conducting the rest of the research. The paper's in its infancy, so it's in the first 3 months, 4 months of working on it. But that's something that we definitely have in mind, and I agree with everything that you said on that.
Thank you very much, Irene. Excellent. Thank you. You're muted again, Sabine.
Gosh, I'm so sorry.
No problem.
Okay. Before we move on again to our peer commentator, I wanted to ask if any members of the audience had any questions. Just checking through the chat and see. Okay, I see Meng Yi, you raised your hand.
Did you put
yes,
the question maybe in the chat?
Oh, sorry. I just thinking you are checking someone who still have a question. Okay. And Erini, thanks for your presentation. And the points and the structure of your presentation are very clear. And also the case example you provide, which really helped me to understand what you are talking about, even though I'm not very in your areas, but I can still be inspired by your presentation. So thanks again. So after your presentation, I have two small questions I want to ask. And the first question is, you mentioned in your conclusion part about the South Africa should not mirror the EU approach to regulating the digital market. So I'm curious, is there have any space from the South Africa digital market for the EU digital market to be referenced? So that's my first question. And my second question is, you mentioned that South Africa prefers a broader method to regulate the digital market. So in your perspective, do you think the EU should consider having a broader method as well? If not, and why? And that's all my question.
Thank you for the excellent questions. on your first question, definitely South Africa has interacted a lot with the DMA, and that was largely seen within the market inquiry that they conducted and released in 2023. They mentioned the DMA various times, and they even stated that they encouraged or want the companies to also comply with the DMA. In the same breath, the inquiry also stated at one point that they did consider creating a regulation of its own, but at this stage, they did not think that it was appropriate. I probably missed that out in my presentation, given the stress and timing. But yeah, you can see that South Africa and the Competition Commission is interacting with the DMA. And again, as we said before, that if they were to consider it, there would be wider considerations that need to be taken into consideration, like the realities of South Africa, and yeah, the social, economical, legal, political, those kind of factors would need to be considered. So yeah, and then your second question was on, if you remind me, it was on, oh, what can the EU learn? So I definitely think that the EU can learn. I think the EU has been learning. I think we have largely seen the EU develop an approach. At the start, maybe 10, 20 years ago, the approach was a lot more relaxed. I think they've become more strong in their approach. And with regards to a broader goals that they may want to consider, I think that may be beneficial. I think the EU is slowly coming to terms with that they cannot keep the same standards and tests that they've used in the past when it comes to considering only pricing costs and efficiency. There are other factors that they need to consider, like innovation and quality. And we can see through the cases and through the DMA, the EU starting to interact with that more, but I definitely think that they can also learn some lessons from other jurisdictions.
Oh, that's interesting. Thanks for your answer.
No worries.
Okay. Thank you, Erini. So now I'd like to move on and introduce the peer commentator, Dr. Somabha Bandopadhay. So Dr. Bandopadhay, the floor is now yours.
Hello, I hope I'm audible.
Yes.
Yes, thank you so much. It was a very different kind of a presentation, I must say. So congratulations on working on a very technical and a very difficult subject matter, as I can understand. I had just one, or rather, this is kind of a comment or maybe a query that I have, is while you are looking at South Africa, why don't you also maybe look at some other regimes which are developing? Because, for example, since I come from India and I have some little idea of the competition regime, and I'm sure you know that it's developing so much, and especially with the monumental changes that we have seen in the past few years, especially with the governmental initiatives and all of that. So I think a lot of things have developed, which is, I guess it would be very much in line with the research objectives and the research questions that you have for the research. So I think, even though I know your scope is limited to South Africa, but maybe it would be nice to bring in these new developing perspectives, either in your concluding chapter or somewhere, if you could, maybe even in the introduction or somewhere, which would only enhance the significance of the topic when it comes to the global south. So I think that is one suggestion that I will have. The other suggestion that I have is with regard to mentioning or maybe having some case studies, if possible, maybe very briefly, of some other very local or indigenous softwares or such products which are trying to maybe compete, and are the ones who are not being able to reach that level. So I was just thinking if you could incorporate those indigenous or local examples to make it more rich. I don't know if you've already provided that, but I was just very curious to know if you have been able to provide for some of them. So I think these are the two major suggestions that I have, which I found could just enrich the topic, because since you are working on this, you are the best person to comment, and we are only here to just give our own suggestions. So so my comments are nothing less than just, coming out of curiosity that I have. So maybe it could be of help to you for incorporation. So all the very best, and looking forward to some great maybe publications in the future.
Thank you so much. Thank you.
Thanks.
Okay, thank you, Bandopadhay. So I'll go through the chat, and I see we have one question so far from Gifty Brew Mensa. So this person says, Erini, well done for the work so far. Can you please elaborate on your methodology in terms of the approach and strategy?
Definitely, yes. Yes, Sabine?
No, go ahead.
Okay, yes, just to elaborate a bit more, as I said before, we've used like a mixed method. So on one side, we've looked at taking a black letter approach, which is collating all the cases, the relevant cases that we want to look at, looking at the regulations, but this also includes looking at reports that are coming out of these countries by the commissions, the judgments, also taking a look at the academic work of academics and their views on what is happening within digital markets. And then the comparative side is kind of bringing those things together and comparing what is happening within the EU to that of South Africa. The data essentially is the statutes, the regulations, and the cases, and comparing the reasonings within the cases, the outcomes of the cases, the reasonings within the reports, the reasonings within the inquiries. Those are all the things that we've been taking into consideration when carrying out this research. And I hope that expands a bit more on the methodology that we've used and the strategy. If there's anything else, please feel free to ask so I can make it a bit more clearer, or if you'd like to contact me via email, that'd be great.
Thank you, Erini.
Yeah, thank you.
Oh, was that Gifty or?
Yes, I was just acknowledging the response. Thank you.
Oh, okay.
No worries.
No worries, thank you. So Erini, I actually do have a question, or kind of question / comment, because I come from an economics background. And I'm actually thinking about my own research on institutions, whether that be institutions in kind of the economic frame connecting with the legal frame. So basically,
yes.
So looking at this in the perspective of, competition and access to markets. So I think it makes sense, and this is kind of harping on what everyone else is saying, that the EU, United States, UK, we have laws on competitions, antitrust, also basically how firms can regulate or perform in a supposedly capitalist type market. And that kind of makes sense because these societies essentially created capitalism and have their own strain of capitalism, which I think sometimes are on the side of like crony capitalism, right? So when you think about access to market, it's always going to be kind of those few dominant that you termed as GAFAM, right? That kind of rule the lay of the land in terms of digital technologies. So I'm also kind of wondering now, in the context of South Africa and maybe other developing countries where their economies are structured differently. I mean, how do you see that, you know, in general affecting competition between firms, or even the legal institutions that are being designed to protect their economy or protect their firms? Like, I mean, do you see it being very closely related to the way the EU and the United States do it, or do you think it's different?
I think that's a great question, and I would have to do a little bit more research on that, on the economies and how they operate. But I think there are some differences in the goals that they want to achieve. I think EU, as I said, it's more focused on efficiency and ensuring lower prices for its consumers, while I think the South African goals, which are stated within the Competition Act 1998, they're very much focused on domestic companies and historically disadvantaged individuals and ensuring that they have access to the markets. And I think in that sense, they do differ. As far as how the economies actually operate and the market structures, I'm not entirely sure, so I'd have to do some more research on that. So I think that's a great question. And maybe I can come back to you with an extensive answer later.
No worries. I mean, that actually
That's
sounds
a great consideration.
Yeah, well, you talked about kind of South Africa's goal. It sounds very much protectionist as opposed to competitive.
Yes.
Okay, so all right. And now just looking at the chat and seeing if any members of the audience has any more questions or comments to chime in. You can either write your questions in the chat or you can use the raise hand icon. Okay, it seems like this is probably all for questions, as I'm not seeing anything new other than folks saying that they're experiencing technological issues. So I will then take
discussion.
Oh, for the technological issues as well?
Yeah.
Yeah, I think it's yeah, I think Microsoft Teams is acting a little finicky these last few days, so I don't think it's just us as well. Okay, then. So I will take this time now to conclude the session and also, you know, thank our discussant, Dr. Masaya, as well as our peer commentator, Dr. Bandopadhay, and our presenter today, Erini. So I want to encourage you all to attend the next seminar, which is titled Violence, Victimization, and Human Rights of the Transgender Community, an empirical study with special reference to West Bengal in India. That will be actually presented by Dr. Somabha Bandopadhay, and that